Having looked at how we can differentiate a term from a representation, we're now going to turn to a specific type of term that gets included in contracts: disclaimers. So disclaimers are terms that are used when businesses try to eliminate or limit their liability. And you might have heard them called different things such as exclusion clauses, exemption clauses, or limitation of liability clauses. They all mean the same thing. They're all kinds of disclaimers. One party is trying to disclaim liability, and in so doing, that limits the rights of the other party. Now, if a disclaimer is effective, it means that one party could be in breach, but they're not going to be liable for breaching their contractual obligations. As you can imagine, this is quite counterintuitive because the whole point of entering a contract is so that you will have legal obligations, but the point of a disclaimer is to get you out of any legal obligations. Okay, so how does the court approach this? Well, it reads these terms in a very specific way. We have the Latin here, contra proferentum, which is saying it's read against the person relying on that term. Another way of saying that is these terms are read very narrowly, something we'll get into when we look at how these rules apply. So the provision or term is read down against the party relying on it. And in that way, they're trying to stop the erosion of the rights of one party in the contract. Some examples of disclaimers where you read something like no liability for loss, injury, or no liability for goods that are stolen or missing if you go into a hotel. There's no liability for loss or injury. Could be if you go in a car park, you might see this, or if you go on some kind of tour. There'll be these kinds of statements which are attempting to limit the liability of the counterparty. So in this module, we're going to look at 3 rules around disclaimers. The first rule, a disclaimer must be part of a contract. Second, they're interpreted narrowly, and disclaimers must not be misrepresented. The third rule. Let's go through those 3. So the first rule is actually pretty simple, right? For you to be able to rely on a disclaimer, it must be part of the contract. That means the other party must know about it prior to the contract forming. This is one of those times when the formation point, the time when the contract is formed, becomes important, because often disclaimers are routinely added to things like signs when you enter a car park or when you go into a hotel room. Any kind of routine low-level contract, there may be a disclaimer. But the issue is, did you know about that disclaimer prior to entering the contract? If you didn't, the other party can't rely on it because you didn't agree to it, right? So disclaimers must form part of the contract. Now, it can do that in a number of ways. If it's in a written document that you then sign, right? So that's why often on a tour or things, they'll actually give you something as part of the agreement process. That way they can say they handed you the disclaimer. Another way is if it's brought to your attention. So a good example of this is a car park sign. So car parks always have signs before you get to the place to take your ticket. Why? Those signs are giving you notice of the disclaimer. So you have to say, was there reasonable notice given? Was the sign in a spot where you would see it prior to entering the contract? That's why the signs are before the boom gates, not after, right? Because once you've taken the ticket, you've agreed. And if you see the sign later, you don't have reasonable notice. So that's an example of being given reasonable notice. Signage is a great example. The third way is if you have prior dealings. So if you regularly parked at a car park and they had a sign in the wrong spot, just say it was in the lift or near the exit, right? You've already agreed and then you see the sign. Well, if it's just a one-off, then that disclaimer doesn't form part of the contract. You didn't have reasonable notice. However, if you see the sign every day, there's prior dealings, then you know about it. So there's actually 3 ways disclaimers can form part of the contract. It's in the written document, you were given reasonable notice, or prior dealings, and you're aware of it from prior dealings. Now, If the disclaimer is in the contract, it's either been written or we've been given reasonable notice or we know about it from prior dealings, then the second rule is that that term will be interpreted narrowly. What does that mean? We're going to concentrate on one example from the Council of the City of Sydney and West, but there's many rules here that help us interpret something narrowly. Here's a way of thinking about it. Basically, you can think of a disclaimer as being interpreted in multiple ways. It's a little bit ambiguous. And so what the courts do is resolve any ambiguity by narrowing it, making it apply as little as possible. Think about this. Just say you go to the city gardens and you want to hire a bike. There's multiple ways you could hire a bike. Maybe you're looking at one of those Lime electric bikes. So they would have terms, and one of those terms would be that they're not liable if you suffer an injury using the bike. Now, does that make sense? Yes, because you might not be able to ride a bike, and if you fall off, it's your fault. You shouldn't have hired a bike if you don't know how to ride one. But sometimes it could be their fault, right? Maybe they didn't maintain the bike, and the front wheel falls off, and you injure yourself. Well, really, they should be liable for that, right? So can you see the difference when they have a disclaimer that says, we're not liable for any injury you suffer while riding our bike? Now, you could read that to mean any injury at all, like even the front wheel falling off because we didn't maintain it, or you could read it to mean any injury that we didn't really contribute to. See? Okay, the courts read it narrowly. You will be liable for those injuries that are, for instance, caused by your lack of maintenance. And that seems only reasonable, right? So that's what's going on here. We have a kind of statement that might be ambiguous, and we read it as narrowly as possible. So what happened in the Council of the City of Sydney and West? Okay, so in that case, a guy had his car stolen from a car park run by the council. So he goes and parks in the car park, goes on his merry way, and there's a sign, there's a disclaimer, it's incorporated saying that they're not liable for any loss that you suffer. Now, in between, a thief comes, breaks into his car, and goes to exit the car park. And in this particular car park, there was a car park attendant, someone employed by the council. And the thief goes to the person and says, oh, I lost my ticket. And the guy goes, lost ticket fee is $50. So he pays the $50 and drives the car away. Now, the council tries to argue we had a disclaimer, we're not liable for any loss. And what the court found was that they're not liable for any loss during the normal operation of a contract. So any disclaimer only covers the normal way a contract would operate or a transaction would operate. In this instance, it wasn't a normal transaction because the normal transaction is you have a parking ticket which you give to the attendant and then you pay. Here, that didn't occur. This was not the normal transaction or the normal operation of a parking contract. And because of that, the disclaimer didn't apply. Now, this is called the four corners rule. Bit confusing. Why? The four corners of the contract, right? A disclaimer only covers the normal operation or the four corners of a contract, what's going on in a normal transaction in the contract. So that's the four corners rule. And it shows you how that disclaimer saying we're not going to be liable for loss is read narrowly to not cover the situation of where someone didn't have a parking ticket. The third and final rule we deal with is that disclaimers can't be misrepresented. What does that mean? That means if there's some interchange or the way the disclaimer is expressed gives the other party the wrong impression about what the disclaimer covers. So the classic case for this is Curtis and Chemical Cleaning, where someone, I think, wanted their wedding dress dry cleaned, took it into the dry cleaners, and there was this no liability for damage clause. The customer raised it with the shop assistant who said, oh yeah, but that's only about beading because we can't be sure about the beading. So they took the dress, cleaned it, and damaged it. And it wasn't the beading that got damaged. It was something else that went wrong in the process. So in that case, the dry cleaners tried to rely on this disclaimer, but the court said, no, it was misrepresented, right? The assistant made it seem like it was only the beading. So your disclaimer doesn't apply to the damage that you've done. So there we have it for disclaimers in this topic. It must be incorporated into the contract, it's read narrowly, and we use the four corners rule, and it can't be misrepresented. If it meets those three, then it can apply, but it will often be knocked out due to the application of one of those three rules. The other thing that's super important to remember is that there are many other factors that apply beyond common law. We're not going to examine them, but we need to remember that Australian consumer law, particularly for consumer transactions, plays a key role here. For instance, you can't exclude consumer guarantees. You can only use disclaimers in prescribed ways, so that means you can't use them some ways. And many one-sided disclaimers would be struck down as unfair contract terms. So disclaimers can have a very limited role, particularly in consumer transactions about the nature of the goods being sold. Whew. Okay, so that's disclaimers. We started by looking at what a term is, the difference between a condition and a warranty. Then we went to look at how we differentiate representations from terms with the three rules, the parole evidence rule, Lestrange rule, and the Dick Bentley Productions rule, before finally we turned to looking at the special case of disclaimers and the three things that are required in order for a disclaimer to be effective. Finally, we look at what happens if you don't do what you said you would. What happens if you breach one of these obligations, a term of the contract?